Kanu to Justice Omotosho. Read me the law or free me. In a stunning courtroom reversal at the Federal High Court in Abuja, Mazi Nnamdi Kanu, the imprisoned leader of the indigenous people of Biafra, IPOB, abandoned plans to call witnesses in his defense and instead filed a no-case submission, boldly declaring that the terrorism charges against him lack any legal foundation in Nigerian law. Representing himself after dismissing his legal team, Kanu challenged the court to cite any applicable statute, leaving Justice James Omotosho to urge consultation with legal experts amid procedural warnings. Kanu's defiant stand. I have no case to answer. The session unfolded before Justice Omotosho, who has presided over the case since its reassignment from Justice Binta Nyako earlier in the proceedings. Kanu, entering the dock with a stack of documents, announced his self-representation and, after reviewing the case file, asserted that the prosecution's evidence fails to establish a prima facie case. His remarks, delivered with fervor, echoed his long-standing contention of political persecution. My lord, I have gone through my case file and realized there is no charge against me. There is no law in this country upon which the prosecution can predicate the charges against me. If there's any, let my lord read it out to me. My lord, is there any? Is there? I will not enter any defense in a charge that does not exist under any law in Nigeria. The charge here does not exist, and I urge you to either release or grant me bail. Kanu's pivot from an earlier intent to summon 23 witnesses, including international figures from the US and Kenya, marks a strategic gamble. He argued that the 7-count charge, centered on allegations of terrorism, seditious broadcasts via Radio Biafra, and incitement, violates constitutional protections and ignores his 2022 Court of Appeal acquittal on grounds of unlawful rendition from Kenya. Though the Supreme Court overturned that ruling in December 2023, remitting the case for trial, Kanu maintains the charges remain baseless and jurisdictionally flawed. Legal observers describe this as a high-stakes move under Section 303 of the Criminal Procedure Act, forcing the court to assess if the prosecution's case, built on witness testimonies and intercepted broadcasts, meets the beyond reasonable doubt threshold without rebuttal evidence from the defense. Visibly concerned, Justice Omotosho interrupted Kanu to explain the 3 post-prosecution options in a criminal trial: opening a defense, resting on the prosecution's case, or filing a no-case submission. Reminding Kanu of his prior ruling upholding a case to answer, the judge granted 7 days for a formal written address but implored, I am begging you in the name of God Almighty to consult properly. I am inclined to grant you the adjournment you seek. I know you are educated, but you are not a lawyer. You need to consult experts in the field. Please make adequate consultation. This is not economics. This is criminal prosecution. Omotosho offered to refer Kanu to the Legal Aid Council or Pro Bono Council, but Kanu declined, insisting on self-representation. Prosecutors, led by Chief Adegboyega Awamolo, SAN, from the Attorney General's office, stood by silently, awaiting the written motion. The court adjourned to November 4th, 5, and 6, 2025 for adoption of addresses, potentially on the no-case plea or defense continuation.